If you'll recall, the difference between a formal and an informal proceeding with regard to either rulemaking or adjudication are that with regard to formal rulemaking, an in-person hearing is required at which cross-examination of witnesses and presentation of evidence is permitted. And, of course, the decision has to be on the record, meaning it has to make justification only to those things that are mentioned in the hearing or during the written comments. Informal proceedings don't require any of these things, of course. Well, the question then becomes, which one should an agency use when adopting a rule? Do they have to use formal? Can they use informal? And is there a legal requirement? Originally, when it was first written, the Administrative Procedure Act was interpreted by courts and by the executive branch to mean that written notice was required, but that agencies could choose to conduct a formal hearing if they wish. So the APA did not require a formal hearing. But in the 1960s, of course, the federal government began to grow. Under Lyndon Johnson and the Great Society, there was a dramatic increase in the growth of the federal government, which meant the federal government was getting more involved in people's lives and its decisions were more consequential. And at the same time, agencies started to use adjudication less and rulemaking more. So rulemaking was becoming a more important part of what agencies did. So they were involved with more things and they were making more rules. And as a result, courts became wary of too much reliance on agency discretion. And this is very interesting, and this is definitely going to be a theme throughout the rest of our semester, and that is, to what extent should judges who are only trained in the law overturn decisions that are reached by bureaucrats who have specialized technical training that the courts don't have? But in any case, courts in the 1960s thought that they probably were not looking at agency decisions heavily enough. And so, in the 1960s, something named hybrid rulemaking started to emerge. Lower courts, not the Supreme Court, but lower courts began to impose it in the 1960s. What is hybrid rulemaking? Well, it's kind of hard to describe, but it's something between formal and informal rulemaking. Obviously, written comments are still taken. That always happens, regardless of what kind of rulemaking. But in addition to the written comments, it's also augmented with additional procedures. Now, those additional procedures are not a full-blown trial-like adjudication. Oftentimes, you will have a hearing, but the decision doesn't need to be on the record, so additional evidence could be considered. The hearing itself isn't required to cover all of the issues that are addressed in the rule. And so essentially courts were saying that in some instances the agency should do more than have just written comments but not necessarily have a full formal hearing. This was sort of summarized quite nicely in the 1976 case by the D.C. Circuit Court of Appeals, Ethyl Corp v. EPA, and it's kind of interesting because this move toward hybrid rulemaking is very clearly associated with one judge. It's a lower court judge, Judge David Bazelon, who became its clearest proponent, and this was a statement he made when he was a D.C. Circuit judge. The best way for courts to guard against unreasonable or erroneous administrative decisions is not for the judges themselves to scrutinize the technical merits of each decision. Rather, it's to establish a decision-making process that assures a reasoned decision that can be held up to the scrutiny of the scientific community and the public. In other words, Bazelon was saying that we as judges do not have a lot of technical know-how, and as a result, we shouldn't necessarily be overturning a lot of their decisions based on their substance, but the judges and the entire country should be assured that the agency did follow some sort of scientific procedures or rational procedures, and if they do go the extra mile to demonstrate that they've used good science, then the judges should be less likely to overturn them on the merits. Substantive review of mathematical and scientific evidence by technically illiterate judges is dangerously unreliable, and it inevitably invites judges of opposing views to make plausible sounding but simplistic judgments of the relative weight to be afforded various pieces of technical data. So he's begging or forcing, I should say, agencies to go above and beyond to assure everybody that its judgments were accurate and correct. Well, this issue was addressed by the United States Supreme Court in a very famous case, the Vermont Yankee case, which was decided by the Supreme Court in 1978. And in this instance, the Supreme Court ultimately rejected David Bazelon's argument. The Supreme Court in this particular case, the lower court had argued that the Nuclear Regulatory Commission needed to do more than informal hearing in a rulemaking instance, and the Supreme Court disagreed. The Supreme Court rejected Bazelon's argument that judges don't have the competence to review agency decisions, so they should insist on more strict procedures. Instead, they said that Congress entrusted this discretion to the agencies, and agencies are more appropriate than we are to judge whether those decisions are correct and whether the proper procedures have been followed or which procedures are appropriate. So this is interesting because the Supreme Court, as it often does, deferred to the expertise of agencies. Now this is very nice, but I suspect that this era is about to come to an end. The Supreme Court in the last few years has been more suspicious of agency deference, and we're going to talk about that more in future lectures. But at least as far as the Vermont Yankee decision goes, the court said essentially that you could not force agencies to do more than was required by law. Now, hybrid rulemaking still occurs. The Vermont Yankee decision did not mean that hybrid rulemaking ended, but it only occurs if Congress requires it. So again, if the Enabling Act says that when making a rule, an agency has to do more, if they have to do it on the record, of course, then a formal hearing is required. But they may also say in the Enabling Act that some other form of due process is required. But if Congress does not require that, then the only thing an agency has to do is solicit written comments. And an agency, of course, they can't be required by a court to adopt hybrid rulemaking, but they certainly can decide to adopt hybrid rulemaking if they choose to. So if it is a particularly complex rule or a rule that will have particularly far-reaching effects, then the agency may decide to have an additional level of due process, but that's entirely up to the agency. Courts can't force them to do it. So agencies are left free to determine the procedures that they see fit within the parameters established by Congress. The decision was a rousing show of support for administrative agencies, but again, I think those days are rapidly ending.